Hello and welcome. My name is Jeremy Glover and it's my pleasure to welcome you to our final Fenwick Elliott webinar before Easter. This week we're taking a look at mediation. Now we all know about the costs of litigation and of the arbitration process, and also the difficulties in stopping once you've started. Once upon a time it was said that litigation is a bit like dancing with a gorilla. You only stop when the gorilla wants to stop. Happily, things are moving on, and ADR can help you step away from the dancing gorilla. And mediation is valuable in that it can lead to flexible, confidential settlements, save time, money, preserve commercial business relationships, but only when it works. So today we're going to be looking at what mediation is, why and how it's used, and provide some practical tips to set up for success. And joining us today, and it's a first for us in our mediation, joining us today together, both in the same room in the office, but two of my colleagues at Fenwick Elliott, partners Karen Gidwani, whose name you can see on the screen, and also Lucinda Robinson. As you'll find out, they both have a wealth of experience about mediation and the construction industry in general, and it's experience gained in a variety of ways. Karen has been with Fenwick Elliott for over 21 years now, and Lucinda, before she joined us, had been working in-house with a leading supplier in the construction industry. So before I hand over to them, just a reminder, you're all on mute. Please send me some questions because I want to ask them to Karen and Lucinda at the end, and you'll be able to find a link to our slides posted on the chat in the webinar. But Lucinda, Karen, the floor is yours.
Thank you. Yes, thanks, Jeremy, and good morning, everybody. So we call this talk Win, Lose or Draw, Mediating Construction Disputes. Often when there's a dispute, you expect ultimately to end up with a winner and a loser, or to do some sort of draw through a settlement negotiation. But what if settlement discussions stall and don't go anywhere? Can you still get a draw, or are you stuck with the win or lose scenario through a more formal form of dispute resolution? This is where mediation often comes into play. It's a tool that you can use to help get you to a compromise. Certainly one of the benefits of mediation is often expressed to be the ability for the parties to come up with their own solution. But that doesn't necessarily mean a draw. And there is a saying that in a successful mediation, everybody feels like they lose, or at least they might not feel like they've won. So today, this is what we're going to look at. Mediating construction disputes, and we're going to have a look at, we can skip the slides, thanks Karen. Just trying to show you our first slide, which lists what we're going to talk about. There we go. So we're going to cover what mediation is, why people mediate, how it works, preparing for mediation, which is always important, managing the mediation on the day, and then we can deal with any questions that you send in to us as we go. So I'm going to dive straight into what mediation is. And mediation is a form of alternative dispute resolution, or ADR, which can be used whether or not more formal proceedings are afoot. So it can run alongside your litigation or your arbitration or adjudication. Or it can even be used before they've started, actually. That's not uncommon at all. And at its heart, mediation is a commercial negotiation, so it's supported by an independent third party. It recognises that parties are struggling to reach agreement on their own, and the mediator is there to help them with the process and get to that result in the end. What the third party is not there to do is to decide it. It is not a decision-making process at all. And it is not for the mediator to impose a decision on the parties. They get to come up with their own result. They decide their own fate. Mediation is confidential, which is really important, and that confidentiality works on a number of levels. So during the mediation, it's common for the mediator to sit with each party individually. Now, those conversations as between the mediator and the party will stay confidential unless you give permission to the mediator to take that information and share it with the other side. In addition to that, the discussions between both the parties, either with or without the mediator on the day, are also confidential. So what happens on tour stays on tour, so it were. Furthermore, and really significantly, the whole process is without prejudice. So you can say whatever you need to say to try and get yourself to a deal within that context of mediation, knowing that it can't be used against you within the proceedings. And it's often the case that perhaps without prejudice information in the form of a short expert report or something is shared in that context, and it won't go beyond the 4 rules of mediation. It is not obligatory. Mediation is a consensual process, and the nature of it being a commercial negotiation, being flexible and being about the parties deciding their own fate, is such that the consensual element is really important. It's not about sticking an answer on the parties. You can choose whether you mediate or not. There is some sort of sometimes there are some restrictions or encouragements, which Karen will talk about shortly. But essentially, it's something you can choose to do or not, and whether you do a deal on the day or not is also entirely up to you. It's perfectly possible that you decide a deal can't be done. If a deal is reached, then it will only be binding if it forms some form of contract in the usual way. So you still need the elements of contract to be there before your deal is a binding arrangement. And it's quite common to take a draft settlement agreement with you so that you can actually sketch out or do the deal on paper, record it, get it in the bag. So, again, I'll let Karen drive.
Why mediate?
Exactly. So why do parties mediate? As I said, they don't have to, but there are lots of good reasons to mediate, and we put some of these up on this slide for you, and they fall into sort of legal categories and practical categories. So starting with legal.
Legal, yes. So I think many people will be aware that if you're in litigation, the court will encourage and facilitate ADR as part of its active case management. So you may be aware of the overriding objective, which underpins the civil procedure rules, which in turn underpin litigation in this country. The White Book, which sets out those CPR, sets out those rules, says that the use of alternative dispute resolution to resolve disputes is an integral part of the litigation process. So that is reflected in 2 ways. It's reflected in the rules themselves, but it's also reflected in pre-action conduct. We have pre-action protocols for many types of dispute, including construction and engineering disputes. And as part of the pre-action protocol, the parties will be encouraged to enter into some form of ADR. And that happens not just through the protocol itself, where you have a letter of claim, a letter of response, and then the parties have to meet on a without prejudice basis, but also that as part of that meeting, the parties have to explore how they might resolve the dispute between them. The rules have been updated for the pre-action protocol for construction and engineering disputes, and it's now possible for the without prejudice meeting that takes place as part of that process to actually take place as a mediation. But even if it doesn't, you still must, at that without prejudice meeting, consider ways of resolving the dispute. Once litigation is commenced, you still have to take into account ADR, and the court will still manage the case with ADR in its mind. So even if you go through the pre-action protocol process, you have your without prejudice meeting, you don't get anywhere, you issue proceedings, you're in court, as the case is managed by the judge, you will be asked at certain times to actively consider ADR. That normally happens at case management conferences, but also in the Technology and Construction Court. When you, before you have a case management conference, you have to fill in a form. It's called a case management information sheet. And the parties at that point will be asked whether they want to stay the case for a month to mediate. And sometimes parties will take that opportunity and will do that. One thing that Lucinda will talk about later is timing, but it may not be the right time to mediate at that point. But throughout the case, the court will push the parties and say, have you mediated? And if you haven't mediated, what might happen is that it sounds in cost consequences. So that's a very important point to take into account. And essentially, if you unreasonably refuse to mediate, then it can have an impact on your cost recovery. Sorry, excuse me. So in court, the general rule on costs is if you win the case, then you get your costs. And that's called costs follow the event. And the civil procedure rules set out a number of rules on costs at Part 44. And what that says is that it gives the court the discretion to make a cost order that is not costs follow the event, taking into account the conduct of the parties. In the case of Halsey against Milton Keynes General NHS Trust, which is a case that goes back to 2004, the Court of Appeal was asked to determine whether the fact that a party had refused to mediate meant that it shouldn't get its costs that it would otherwise get. And what the court said was, if a party unreasonably refuses to mediate, then the court can make an order that it shouldn't get its costs that it would normally get. Now, the burden on proving that behaviour is on the losing party. They have to show that the conduct was unreasonable. But the court did give some guidance as to what is reasonable and what is unreasonable behaviour. Lord Justice Dyson identified a list which was non-exhaustive, but he said you must consider the nature of the dispute, the merits of the case, other settlement options, the cost of mediation, delay, and prospects of success. So that's quite a wide range of things to take into account. In a later case called the Earl of Malmesbury against Strutt and Parker, which was in 2008, the court also held that the Halsey principles would apply to unreasonable conduct in mediation, as well as before mediation or when mediation is proposed. Whether conduct is reasonable or unreasonable is actually quite difficult to say in the abstract. It very much depends on the circumstances of the case, and your legal representatives will normally have a good feel for what is reasonable and what is unreasonable. There have been numerous cases in the courts on behaviour, and I've got some examples of both, but it really does depend on the type of case. So some examples of unreasonable refusals were where the party argued it was an all or nothing case, and therefore they couldn't possibly mediate, and the court disagreed. The court said, no, you can mediate in that sort of circumstance. Another one where the nature of the case was found to lend itself to mediation, and the cost of mediation was very small compared to the ultimate amount in dispute. And another one where the judge held that no defence, however strong, means that a party shouldn't mediate. On the other hand, there have been cases where people have reasonably been found to be reasonable in their refusal to mediate. Examples of those are where the mediation would not have achieved an outcome as good as the judgment did. And the judge said, well, if they mediated, they never would have got what they got here. So actually that was fine. There was another case where the parties were simply too far apart, and you do get that. And then there was another case where the issues were so legally complex that actually mediation was considered to be difficult in that case. But I think that would be quite a rare case. I think another point about not mediating, and I don't think there's any case law on this, is where parties both agree that it's not right to mediate. And often that's a timing thing. At the start of a case, you might say, well, look, we're so far apart and we haven't actually produced key documents to each other or expert reports to each other. This is not the right time to mediate. Let's see how we get on. Let's perhaps mediate after disclosure. And I've not heard of a case where parties have been criticised for agreeing not to mediate. And I think it'd be very difficult for one party to argue that there had been unreasonable behaviour in a situation where both parties had agreed that they should mediate. So I think that's something to take into account.
Yeah, I agree. Another reason that might give you quite a hard push towards mediation is if it says in your contract that you have to do it. So you always need to start with your contract in a construction dispute because it sets out the rules for so many things, as you'll be aware. Within the dispute resolution procedure in the contract, you may well find mediation is mentioned. It's quite common for a contract to say the parties shall give serious thought to mediation. So it's not obligatory, again, tying in with that consensual nature of the process, but there's a good hard shove and a good suggestion that it would be sensible and an obligation at least to talk about it. So you might find that. Occasionally, and this tends to be more in bespoke contracts, you can find an obligation that actually before you can take any further step, except perhaps adjudication, but before you can take any other further step towards formal litigation or arbitration, you have to mediate first. And that might be a good thing. On a practical level, it might actually unlock things, or at least narrow a dispute, even if you can't manage to do a deal at the mediation. However, it can also throw up some real challenges. So, for example, if you are towards the end of the limitation period and you've got to get that mediation in before the limitation period expires, then you could be up against it, because in order to have a mediation, you've got to coordinate diaries, make sure the other party actually agree to it. And even if they do agree, they might not, in fact, get into that mediation on time. So it's one of those points. It should always be good practice anyway. If you're dealing with a dispute, look first at the dispute resolution process in your contract, just in case there's a bear trap in there somewhere. Also, again, it could prove to be a waste of money if, as Karen says, you're at that time when both parties recognise mediations are not going to achieve much yet, because there's not enough information known for either party to really make any moves in a mediation. Then it may be that it's a waste of money. But there we go.
Next reason, often it works. So we've got some stats from CEDA, who are the Centre for Effective Dispute Resolution, have been around for many years and have been at the forefront of mediation and other forms of ADR. And the latest figures from their mediation audit from 2021, which takes the stats to March 2020, and I'll come on to pandemic, but there's a 93% settlement rate in the mediations that they were aware of, with 72% settling on the day and 21% settling shortly afterwards. There also seems to be a rise in the use of mediation. They said between 2018 and 2020, there had been a 38% increase in the use of mediation, which I think is quite interesting. Obviously, mediation traditionally was a face-to-face affair. You would, all of you, be in a room, and I'll come on to how it all works. But obviously with the pandemic, that changed things, and now there is a tendency to mediate online or in a hybrid setting. CEDA say it's very successful, and actually I looked at the stats today, and I'm not entirely sure about this, but they say that with their online mediation, they have a settlement rate of 91%, and that's high. I have to admit, I have mediated online during the last 18 months, 2 years. I found it more challenging than mediating in person. I think there is an issue with not being able to read the room in a way that you can when you're in the room physically with people. But done properly, and I think with experience, it can work.
I think my experience chimes exactly with yours, Karen. Yeah. I also mediated during the pandemic online, and we didn't settle on the day. We settled not too long afterwards, so it definitely helped us get there in the end. But on the day, we really missed the ability to see people's faces and really interact with them one-on-one. And we found that some of the people on the other side were sitting around a boardroom table, which for them made a lot of sense because they were together and they could share their information and ideas. But for us trying to communicate with them, we couldn't really see anyone's faces clearly, and that was difficult.
That's exactly the same problem we had. And actually, one of the things that I thought that lends itself to is the inability to break out of group thought.
Yes.
So absolutely, the parties will go in quite entrenched. We're right, they're wrong, and they're all sitting around the table and they're all talking each other up. And you don't have the physical presence of somebody to go in there and break it up in a way that you do when you're in person.
Yeah, completely agree. So it's not to say it doesn't work, and obviously the statistics say it does, but we must be in the small percentage that don't. So another reason why people do it, and in my view, what perhaps is the most useful part of it, and why I'm a particular advocate for mediation really, is that it's so flexible. It's entirely up to the parties how they resolve their disputes. The solution is entirely in their hands, and that enables them to be a lot more creative in finding the solution than a court could be, or even an adjudicator, frankly. So there are all sorts of things they can do. So yes, of course, you could decide that one party is going to pay the other party a great big chunk of money within 7 days, and that's the end of it. That does happen. But so often you also find that one of the parties might actually not pay cash, but might carry out some remedial works. And I've seen that work very effectively, where the mediator said, right, in the first half an hour, he had everybody talking about, well, how would you solve this? And they started talking about what works needed to be done, and it led on to a solution that would take you to one of the parties carrying out works, which for them was considerably cheaper and actually paid off the litigation risk of continuing. So that was a really good option. It's also very common that payment is broken into instalments, which can make it much easier to swallow for the paying party. It can include opportunities around future work or opportunities to bid for future work, which if it's a mediation between two parties that commonly work together or need to rely on each other for trade, then actually that can be a really helpful thing. It could involve an apology or a press release or some form of communication that takes the sting out of it for one party, or allows some face to be saved, or actually just makes somebody feel that they've had some justice, which even if you win in litigation, you don't always feel that, you know, you've been cared for in the same way that mediation can do that. There are some other things as well. I think you came across something to do with the bet.
One of the very first cases, actually, when I was at Fenwick Elliott, I was asked to go and place a bet on a horse because the parties they couldn't agree what to do with the last, I can't even remember, £100, and they decided they'd just put it on a horse and split the winnings, and then the horse lost, obviously. So that was fine.
They split the nothing. But,
So
it does, but that is a great, just sort of personality-filled example of how mediation can just change the dynamic, make it easier to get to that deal. And as an added bonus, as I mentioned earlier, it's all confidential, so it's not as though, you know, you're going to end up with a reported judgment, which could be very detrimental to the parties, particularly if, you know, it's not uncommon for a party to feel that actually if they lose in litigation in one case because perhaps their works haven't been up to scratch, perhaps a similar issue might be live on other projects, and if the case is reported in one, then it could actually trigger further litigation from other sources, and mediation sweeps all that under the carpet. You know, it's all behind closed doors, which might help out in the bigger commercial picture. And again, as part of all of this, it can help relationships. So it's often said that, you know, mediation can help preserve relationships. I've seen examples where it really doesn't, and despite the fact they did a deal, parties still hate each other at the end of it, and they're not going to be friends, whatever happens.
But I've seen the opposite, where they all go down to the pub afterwards.
Exactly. And you think, why were we here? Why were we here? You're friends, really. And again, especially where they're relying on each other for future work, that is a really important part of it all. So those are the reasons we think parties should mediate. So how does it work?
So this is the nuts and bolts. So the first point is, obviously, it's a consensual process. So to some extent, it's up to the parties to agree how it works, but there is a way that it is generally done. The first thing you need to do is identify the mediator and a date, time and location to suit. And how those things interact will depend on the case. But for example, if time is really important, then good mediators tend to be in quite high demand. So you may have to be flexible around who your mediator is. If time is less important, you can say, oh, well, I want, you know, Miss X, and if she can only do it in 2 months' time, fine, we'll wait 2 months. So it will just depend on your particular circumstances. But those things do interact. In terms of identifying the mediator, what generally happens is that each party will suggest a few names. In construction, there are a group of quite well-known and quite well-respected mediators who people tend to go to. You need to think about, different mediators have different personalities, so you need to think about who is the right mediator for your case. Some people can be a bit more robust than others. I'll come on to the different types of mediation and different styles later. So you need to have a think about that. Often people will have had experience with mediators and will be able to say, well, so-and-so did this type of case before and actually they did a really good job, or not, as the case may be. Then you need to think about timing. Timing in a few senses. Firstly, how long do you need? Most mediations are a day, but you can have multi-party cases. You can have very complex cases, and then you may need more than a day. You may need 2 or possibly even 3. And then the day will have, those 3 days or so will have to be structured very well so that time is used properly. You also need to consider in timing availability. Who are the key people that need to be at that mediation, and therefore who needs to put time aside in their diary? Often you need people who are quite high up in the company, who've got the authority to settle. And they tend to be very busy people with very busy diaries.
They do, and on that note, they might need to obtain someone else's permission.
Absolutely, I was going to come on to that. So they need authority. So you may need time to put in place board approvals, approvals from banks, approvals from lenders. So you've got to build all of that into the process. So you may not just be able to say, oh, let's all mediate next week. And there is a time of year where you know you're never going to get a mediation for 3 or 4 months, and that's when you decide to mediate in June and make the offer, because everybody will sequentially be on holiday until September, and yeah, it's very difficult to get a mediation in over the summer. In terms of location, you need to think about where parties are based, whether, again, it can depend on personalities and how far apart the parties are. Sometimes a law firm will say, well, we can mediate at our offices, and I've actually never had any problem with that. We've had mediations here, but sometimes people say, oh, can't go to the enemy, that'd be terrible. So we don't do that. So there are plenty of places though that offer meeting rooms. You need at least 1 big room for the main session, and then breakout rooms for the parties and for the mediator. Once the mediator's been identified, there's a formal appointment process. They'll have terms and conditions that the parties have to agree and sign up to. They will also generally produce a mediation agreement, which is a fairly short standard document, which will cover things like confidentiality, who's attending, and 2 or 3 procedural steps which tend to take place, which are, firstly, the mediator will want a short set of agreed documents, and they will want only a file or so. So you've got to keep it to the most important things. No mediator is going to thank you for volumes and volumes of files, and they won't read them. The second thing is that parties generally produce a position paper. It tends to be a short position paper, often a page limit is put on it, maybe 15, 20 pages. And what the mediator will be interested in is the financial position of parties, I think, first and foremost. And then the mediator will often ask for details of your costs to date, so that they can do that cost-benefit analysis as part of the mediation. And then generally a mediator will want to have a phone call or a Teams meeting with the legal representative of each party separately in advance of the mediation to get a feel for positions, and that can allow them to hit the ground running on the day of the mediation. Separately to that procedure, you should be looking to have a preparation, or even more than one preparation meeting before the mediation with legal representatives and potentially experts or technical advisors, to identify what position is going to be taken, strengths, weaknesses, how you're going to deal with those, where ultimately your negotiating position may end up. That may be a precursor to going off to get that board approval, so that you know what your limits are and you know who's authorised to do what. On the day, the mediation should be managed by the mediator. The mediator may bring along an assistant or a pupil to watch and help. The structure will generally be that the first thing you do is all sit down in the same room together, and that's called the plenary session. And the mediator manages that, and that's generally, each party will spend 5 or 10 minutes putting forward their position. But it's also, whilst the legal representative often does that, it's also a chance for the client to get something off their chest, and that often works. They just feel that they've had that chance to say, I'm really upset with you. You didn't do what you said you were going to do.
Exactly.
And
it's really important, actually.
Yeah, it really makes them feel that they've
been heard.
Yes, absolutely.
Yeah.
So you have that, and then how the mediation goes from there will very much depend on the case and the mediator, but often the mediator might try and have a joint discussion to begin with to try and explore certain areas where he or she thinks there's potential to compromise. They will then ask everybody to go into their separate rooms, and then there's a bit of shuttle diplomacy, and they will go between parties. And this is actually the point where things can get quite critical, because there can be a lot of time just sitting around not doing very much. And a good mediator, I think, will get people thinking about things, perhaps undertaking certain tasks, whilst they're not in the room with them and working with the other party. Otherwise, you're leaving a party to sit there for maybe 2 hours without any idea of what's going on. And that echo chamber and that group thought will start again, and so, why are we here? What's the point? Why are we spending this much money?
Yeah.
So it is important to try and focus parties on doing constructive tasks to try and move the mediation forward. Generally, offers tend to start to come in around lunchtime, a bit after lunch. It will generally be an offer that is totally unacceptable to either side. And then it's a matter of, you get a feeling of whether this is going to go and whether it's going to be a proper long negotiation, or whether actually it's coats on, we're off. And most mediations, people get a bit agitated, and then they start to settle down, and then people start to talk to each other, and it's that sort of latter part of the afternoon into the evening that the progress gets made. Going back to availability, it's really important that whoever is making the decisions can stay late. Mediations do not just finish at 6 o'clock. Most successful mediations I have done have gone on late. I think I've never gone past midnight, but I've gone close to midnight.
I have too.
Yeah, a number of times.
Yeah.
So that is very important, and it indicates engagement from the other side. All going well, you get a settlement that day. Then you've got to be in a position to document it. You can't. The worst thing you could do is get a settlement and then walk away and not get it written down, because everyone will change their minds having gone home and slept overnight. So you need to be prepared to get that in writing, which is another reason to have a legal representative there to try and get that written down. I've got another point to make on that later, but going with a draft settlement agreement is helpful, because it gets that process going. Yeah, absolutely. If you don't settle on the day, and actually I would say a good number of mediations where we've eventually got to settlement, for me, haven't settled on the day, it does often oil the wheels. And even though you'll feel quite disillusioned that you didn't get settlement that day, there may be enough to get people talking, and within the next 4, 5, 6 weeks, people come closer and closer, and then finally you do get a deal. So that's good. And mediators will generally say, let me help you beyond the mediation, and they will still carry on. They'll phone the parties, they'll try and help bring the parties together. So it's not the end of the mediation if you don't get a deal on the day.
It can be just an accelerator.
Yeah, absolutely.
Okay, so how do we prepare for it then? So time it right. We've discussed this a little bit already, really. So too early, and nobody really understands their case well enough. They're not entirely sure why they need to be nervous, or they're waiting to see whether or not they can find something useful in a later stage of the process. So if it's too early, it might not work. If the parties don't appreciate their weaknesses, or they believe they'll be able to do better later. Or it might be that they just don't have anything to persuade the other side. So ultimately, this is a commercial negotiation. You do have to persuade the other party to move. And if you haven't got anything like, for example, an expert report or some backup on your numbers, or a crucial document that demonstrates you're onto a bit of a winner, then you might just not have enough to tip the other side into an agreement. And it can be immensely frustrating, actually. I've been to a couple of mediations where the other side just had not fully prepared, and we got there and it became very obvious very early that they hadn't done the work that they needed to do to understand the case, and they weren't going to be able to say anything more than what they'd already said beforehand, and it was a waste of time. There are a few things you can do to try and manage this risk. So first and foremost, secure a commitment from the other side that actually they are buying into this process and it's not just lip service. And you can get the mediator to help with that. So usually before the mediation, he'll give each legal representative a call and say, hi, I'm your mediator for the day, just want to explore a couple of points with you. And you can ask the mediator there for their take on how committed the other party is. And that's quite a useful thing to do. You can also sometimes tell from their position statement, actually, whether or not they've put the work in. If you find yourself, nevertheless, stuck in a mediation you have effectively paid for and the other side clearly aren't there to play ball, then there are some other things that you can do. So you might be able to use the opportunity to pull the commercial leads to one side, or let them go and have a conversation, see whether, as they're both in the same place at the same time, if they can agree anything, either one or two of the points that are in dispute, or perhaps a process that might help unlock things. Similarly, if there are QSs involved and you've got two of them in the room, can they make any progress on figures as figures, even if you can't decide on principles? And similarly, if you've got the lawyers in the room, are there any legal principles that they could make some headway on whilst you're there? So you might be able to salvage something at that stage. Conversely, it can be too late to mediate, and sort of one thing could be if actually you're nearly there, you're nearly at trial, you're knocking on the door, brief fees for counsel have been incurred and all the work has been done, it might just be too late. Now, you do find that the cases settle on the door of trial, so perhaps on one hand it isn't too late, but it may be that the parties feel that they've done it now, they might as well see if they can get the result they want. It will depend at that stage how much risk they feel they're facing, I think, on a cost-benefit analysis. So the sweet spot tends to be somewhere around either pre-action, when actually they've gone through the pre-action exchange of correspondence and there's a meeting there. If there's enough in that process, some pre-action processes go on quite some time and go into quite some detail. So it may be that is a good time to do it, particularly if one or other of the parties is feeling under pressure. Or after pleadings have been exchanged, and either just before or just after the first CMC, to see whether or not they can do a deal. That's not to say you can't mediate later. Of course you can. You can mediate at any stage, but those tend to be the sort of obvious times to think about it.
In terms of style of mediation, there are two recognised styles, evaluative and facilitative, and they are really what they say on the tin. Evaluation is an approach that focuses really on the strengths and weaknesses of the parties' cases in order to convince parties that they should settle. Whereas if you're being facilitative, you're facilitating, perhaps you're communicating, you're bringing things out, your focus is slightly different. In reality, most mediators will use a mix of both, but some may lean towards one more than the other. But the other thing to bear in mind with the evaluative process is that some mediators will offer to provide a non-binding evaluation of the merits of the case at the end of the mediation. And you need to think very carefully about whether you want to do that. I have to admit, I have never had a case where we have taken up that offer. And I think the reason for that is that if you're the party who wants it, because it has to be consensual, so it's got to be agreed by both parties. And if you're the party who thinks, this would be really helpful because it'll tell the other side that they've got a difficulty with their case, the other side don't want it, so they're not going to agree, and vice versa. So I've never had one.
Yeah, I've discussed it with people a few times, but not actually done it. And I think I've only really known of one example where it was used, and I'm not convinced it was helpful in the end. Actually, it goes back to how much information you give the mediator beforehand. Right. If they're only making a decision, or they're giving advice based on one folder of information, and actually you would have given a judge 500 folders. It's not.
It can actually be quite dangerous because you then, if you have something that isn't fully informed, you may then have a party who uses that for the remainder of the case without realising that actually doesn't help.
No, exactly. So Karen's talked about selecting a mediator before, so I'm not going to say too much more on that, other than just to flag that actually sometimes you might want a mediator who is at heart a lawyer, so perhaps a barrister or something, because particularly if there's something complicated in the legal aspect of the case that needs unlocking, they can bring their experience to bear very helpfully if they're testing each side on their cases in their individual sessions. Sometimes actually that's not helpful, and you might want a more commercial focused individual who's going to stand back and look at the numbers, so that's always worth bearing in mind. But then also this point about picking the right personality fit with your folks, that's so important. And what really brought it home to me was actually right at the very beginning when I did my first 2 mediations ever. They were such a contrast. The first chap immediately realised he was dealing with property developers who were very concerned about the cash and not so bothered about the principal. They wanted to know what the numbers were going to do and how that was going to impact on their financing. So he just talked about numbers all day. Everybody had a chance to express themselves at the beginning, and as soon as he came in the room, he drew up on the flip chart, this is how much it costs you if you win, this is how much it costs you if you lose, this is the best you can do, this is an okay remit, and then ask people to plot, you know, what's your bottom line on this, where are you going on it? And of course we didn't always share that information straight away, but having the numbers on the wall from the outset helped those people get to the deal. It was the right approach for the right people. We'd done a deal by 3:30 in the afternoon, which I think is my record. So
That's good.
That was very good. On another occasion, shortly after that, we had a mediator who turns up seeming quite bored and uninterested actually, and he dispensed completely with the plenary session, so we didn't have one at all.
It's very strange.
It was strange,
Yeah.
and it really it was a real shame because both parties needed to vent, and even though they sort of suggested it, he wasn't having it, and everyone went home by 3:30 and we didn't have a deal, and it was completely the wrong animal for that particular mediation. So yes, before you pick one, get some intel on their approach and speak to people who've used them before.
I've had issues where we went with a very robust personality who unfortunately clashed with the very robust commercial director personality of my client, and that didn't help the mediation, unfortunately. Okay.
And on personalities.
So who should attend? Well, the first, well, I would say obviously the right people need to attend, and I would divide that into 3 groups of people. So you've got the party, obviously, the legal representatives, and then any technical or other advisors. In terms of the party, you need the key decision makers there. They can't be on the end of it. Well, I mean, they could be on the end of a telephone, but it's not desirable. They should be in the room because that's where the decision has to be made. And they may need, as we said before, they may need to get pre-approval from the board or shareholders or lenders, but they need to be there, and they need to be there for the day and possibly the evening. The other thing to consider is if you've got insurers involved, you need to make sure that insurers are on board with the mediation and also send somebody who has authority to settle. And I mean, that is really key. And one of the things that I always do before mediating is write to the other side and say, have you got insurers involved? Who is coming to the mediation? Please confirm they have authority to settle. And if I don't get the answer that they do have that authority, then I think it's reasonable. I mean, that's my personal view. It's not proven in the cases, but it would be reasonable to say, no, we can't go ahead until you've got somebody who is coming to this mediation who's serious about it. So that's party representatives. Oh, and sorry, one other thing. If I think you touched on this earlier, but if you have somebody who has a good relationship with the other side and who might be able to help get to a resolution because of that relationship, that's a good person to bring on to mediation too.
Likewise, I have suggested people are left behind because for the opposite reason, actually, they're going to clash.
What you don't necessarily need is somebody who knows every single thing about the project. In fact, that can sometimes be difficult and counterproductive because you'll be trying to get to an agreement at a fairly high level, and they'll be saying, yes, but what about what happened on this particular day at this particular time? And sometimes you just have to take that step back. But there is a balance because you do need to have some detail in order to know that what you're doing is right. So it is a balance. On the legal representative side, you need somebody, if you've taken the decision that a legal representative will do the position speech, as it were, in the plenary session, then you need somebody who's able to do that and knows enough about the case to do that. You also need somebody who can draft the settlement agreement and is capable of doing that with knowledge of the case. And also the settlement agreement might be quite complex, because in a situation, as Lucinda said, where you might agree that defects are going to be rectified, that's actually a defect rectification agreement as well as a settlement agreement. And there are provisions there that could be quite complicated. Certainly in my experience are quite complicated. So you need to be able to have people there who are able to do that. It's unusual for counsel to attend mediation. I have had one or two where they have, for particular reasons, particularly if there's a very complex legal issue involved, but generally counsel don't tend to attend. Then you need to consider whether you need any other technical advisors there. Sometimes they are best on the end of a telephone, because it's every person in the room the client is paying for. So if it's just that you might need your quantum guy there for half a day or to have an hour's conversation with somebody, then you can say, just come for the morning, or actually you can say to your structural engineer, I know that this particular issue might come up, but I don't think I need you all day, so perhaps if you could just be available so that if it does come up, I can ring you up and ask you about it. That's one way of handling it. Generally, a cast of thousands is not helpful, because everybody wants to have their say, and it can confuse matters. It can be difficult for the mediator to get through all of that. I would say maybe about 7 or 8 people is about right per party. But again, it will depend on the case.
Yeah, and you might not need that many, actually. No. Okay, and then in terms of preparing your case and your numbers, Karen touched on this already, so I won't spend too long on it, but it's really important to understand the strengths of your case and what you can use in the mediation to show those off. And likewise, you can anticipate that the mediator is really going to probe you on your weaknesses. So when they're sitting with you, testing you on those weak points, is there anything that you can bring to the mediation in terms of documentation or points or arguments that you can give to the mediator to take back to the other side to explain why they're not as bad as they might think they are. So that's really important to do. And part of that will happen when you draft your position statement. You'll have to think all of that through anyway. You also need to think about your numbers. Really important that you think about your numbers. What's your bottom line? What's your target? What's a happy medium in the middle? And also those other options, as well as just numbers, what you'll accept and what you won't accept. What else might you be able to bring to the table that you might be able to include in a deal? Or what might you want from the other side that would help you accept something less or pay something more? Yeah. And then of all of that information you've gathered, what are you happy to share with the mediator, and what actually do you need to keep between yourselves? I think that's probably it on that. So if we skip ahead to managing the mediation
on the day. So we've touched on position papers, key documents, costs, and the mediation, the draft settlement agreement. I wouldn't advise taking very much actually on the day, and if you need detailed information, normally it's available electronically in this day and age anyway, but I would not, and the mediator doesn't want to be drowned in paper before the mediation. So I'd say the most essential documents and the key points, I would normally take a copy of the position papers, up-to-date details of costs, because everybody will want to know that, draft settlement agreement, and any notes that I have made in preparation for the mediation, which may have come out of our pre-preparation meetings, and which will cover things, as Lucinda said, what are we doing to persuade the mediator? Because you do have to persuade the mediator that what our position is the right position, and therefore where we want to be for our settlement is the right settlement. So that's what I do, I think, in terms of the preparation. Sometimes the mediation agreement is signed on the day, that can just depend. But I'd say very little really to take with you.
Yeah. And then in terms of what actually happens, the format for the day, as Karen said, it will be determined by the mediator. He will decide, or she will decide, how the format works. Typical to start with the plenary session, and as we've said, it can be so important just to let people say their piece. The mediator will manage that. So if he feels that it's descending into chaos and people are getting a little bit stroppy with each other, then he will draw a line and stop that. Alternatively, it might be if things are becoming actually quite constructive, we might be able to get discussions on certain points going. That usually happens first. That's not to say there won't be more of them during the course of the day, but what tends to happen later is that subgroups will be selected. So perhaps experts might come together, or people to talk about the numbers might come together, or the commercial leads might come together, maybe with or without legal representatives. The mediator will have a plan or develop a plan as the day progresses as to who he thinks is going to make headway with whom, and sort of bring all that together.
Yeah, that's absolutely right. Everybody needs to do quite a lot of work. It's not just down to the mediator to shuttle between the parties, kiss and like, trying to get to an agreement. You've got to go in prepared. If you don't go in prepared, it just won't work. And I had a mediation quite recently where it was really clear that the other side had not done the work on the quantum. And without that work, we just couldn't get anywhere. And it was very, very, it was quite annoying actually, because I think if you put the work in, you get the result out.
Yes.
And it shouldn't be a tick box exercise, because it's not a cheap exercise. You've got to pay for the mediator, you've got to pay for all the people who are attending the mediation, you've got to pay for the preparation of the mediation. So people do need to take it seriously.
Yeah, absolutely. Completely agree with you. And I think there's been a change, it seems to me, over time. So the first mediations that I was involved in, it was quite common. We always said as a joke to the client, well, not really a joke, actually, decent advice to bring a paper, because you'll be sitting around for a while, you might need to read. I found more recently that the mediators really are making parties work, and actually in the last 4 or 5 I've been to, there actually hasn't been much sitting around, but we've been given tasks to do.
I think the sitting around is when discontent and disillusionment really set in, and that's important to try and keep that at bay.
Yeah,
because most people, to be fair, most people do go into it with a fairly cynical view to begin with.
They do, yeah.
Yeah.
And I mean, finally, on that note, I mean, it's a long day, mediation. You know, you need to start early so you can get all the little intros out of the way and actually move on to the meat of things. And as Karen said earlier, it can go really quite late by the time you've got to an agreement and you're trying to document it before you all sort of collapse into bed. So yeah, it can, you do need to keep your energy levels up. And I think we always make sure that we're preparing clients for that and make sure that you've got refreshments. So old school tactics of keeping the opposition in the small rooms and depriving them of cake throughout the course of the day. That can happen.
Absolutely. I mean,
we've all been in the cupboards.
Yes.
Yeah, we've all been in the cupboards in somebody's office. Yeah. But actually, you don't have to put up with that. You know, you can, if your client needs some air, they can go and get a coffee from outside and come back again. You can go for a walk around the block. Just keep the mediator advised of what you're doing. And if you do need to take a break, then there will be opportunity to do it, and it might make sense to do it. But for all its challenges, actually mediation does work, as the CEDA results show, whether it's on the day or shortly thereafter. And again, although you may feel a bit disgruntled because no one's ever quite happy with the compromise at the end, it does save an awful lot of time, energy, risk, cost in the long run.
Yeah, it allows businesses to just get on with what they're meant to be doing rather than litigation or arbitration.
Exactly. And as we've said, you can choose your own result. There we go.
Excellent. Well, thank you both very much. That was really entertaining, and also, you know, I've been learning a few tips myself. Just a postscript to the case Karen mentioned about putting a bet on. I was part of a mediation a few months after that, where we got down to a similar situation where there's just one pot of money left, and the suggestion of putting a bet on was raised, but the parties were horrified. But it turned out all right, because they were so horrified. They said to the mediator, well, you decide. Now, I know that lots of mediators, they don't feel it's their place to actually make decisions, but given where we were, it provided the stimulus, and the mediator decided that party A should have the money, and the mediation was a success. So, you know, many different ways to achieve a settlement, and a lot is dependent on the identity and skill set of the mediator. With that in mind, we have actually had a couple of questions about the identity of the mediator themselves, and I think they're related. The first question was early on in the talk, and there's sort of suggestions that seem to be coming through that mediator is likely to be a lawyer or a solicitor. And the question was, how are they going to understand construction? How are they going to understand delay analysis, programs, etc.? Do mediators themselves use third-party consultants? And the related question was, how important is it for the mediator to have some understanding of the matter if it involves building engineering services? What if how important is it that the mediator actually understands some of the technical stuff?
Yeah, go for it.
So yes, it is important they understand it. Normally, if it's a lawyer mediator, it will be somebody, you'll be choosing somebody with a construction background, so they're used to construction disputes. So I would say, I've done quite a lot of construction or mediations, obviously, with lawyer mediators. We've never had an issue with them not understanding the technical aspect of the case, because they will have done delay analysis. They will have practiced it, so they will have done delay analysis. They will have looked at quantum claims. They will have had cases involving defects or building services. And often, actually, when you get their CVs, they will say on the CVs, have been involved in, for example, PFI projects, have been involved in this type of project. Speaking of PFI projects, I had a mediation a number of years ago where we were mediating over the financial model. So it's not really a construction mediator. So we were looking for somebody who had that sort of experience, and we found one by looking at CVs.
Yeah.
So that's what you do, I think.
I think that's absolutely right. And I would add to that, actually, and a point you made earlier, Karen, is that when you're in the mediation context, it's a commercial negotiation. It's not a decision-making process around who is right or wrong on the technical issue at hand. So yes, they have to understand the context of the dispute, what everyone's arguing about, and where the weaknesses and the strengths are of either side. But that isn't the same as having to sort of have necessarily an engineering background, or I've certainly not seen a mediator need to have an expert to support them or a consultant to support them.
Okay.
I think at that level, if you're going into finite detail in the mediation about the technical aspects of how something works, you're probably going a little bit off track, actually, and you need to just stand back a little bit.
Or if it was not a legal dispute, but something to do with a particular engineering concept, you might want an engineer.
Yeah,
you get like engineering mediators. They are out there. But I think, generally, if you think the case is about to be put before a judge or an arbitral panel, who are likely to be lawyers by background as well, it's the same sort of analogy.
Okay, perfect.
Sorry, one other thing is that what I say, going back to you've got to work. Part of writing a good position paper is it's a bit like what you would do when you go to the court. You would say, look, this is the technical issue, and I'm going to explain it to you in a way that you can understand it, and that is part of doing proper preparation.
And pictures and documents and photos help. Actually, that can, if it is concentrating on that, I've seen very effectively in a mediation, in the plenary situation, people bring up the plans or the drawings or the photos and literally walk the mediator through, this is what we're talking about, and this is the bit that doesn't quite work, and make it very visual.
Yeah.
So you can use that as a strategy to help them get into it if you need to.
Yeah, no, that's true. And once upon a time, I'm pretty certain we took effectively a sandpit and some tonka toys along to demonstrate the time taken to load and sort of take materials to and from a road that was being built, just to make sure there's no doubt, get the message across. And just by way of a final quick question, if a party to the mediation has the benefit of adjudication or litigation legal expenses or expense insurance, should they be revealing this to the mediator or during the mediation?
I'm not sure they're obliged to, although I would actually have to check that. I think you would probably let the mediator know in that sort of situation, because it will impact on how you approach the settlement. You may not let the other party know, and the mediator will always say, tell me what I cannot say to the other party, and the big red box will go around it, and they won't say it.
But they might also tell you whether they think it would be helpful to share something.
Yeah, I mean, I think that must be right, because it's important that the mediator knows, I think, because the mediator is the person who's got to gather all the information together to try and fully understand all the key roads to settling the dispute, and how the parties cost is part of that. So I think you should let the mediator know. Karen, Lucinda, thank you again. That's been very entertaining and very informative. So thank you both very much.
Thanks, Jeremy.
Thank you.
Thanks everybody. Bye-bye.
Bye.
Yep. So yeah, our next webinar in May about the NEC Executive Programme. Click on the QR code if you want to find some more details. But thank you all very much and see you all soon.